Our next speaker will be Oliver Bell, and up after him will be Christine Owens. Good morning, Mr. Bell.
Morning, ma'am. Madam Chair, members of the board, it is great to be here this morning. Also, I'd like to acknowledge the guests and members of the audience we have from organized labor, employers, trade associations, and most of all, the employees present or viewing this via webcast who have the most at stake in this entire process. Thank you for allowing me the opportunity to share my perspective with you. My name is Oliver Bell. I am from Austin, Texas. I am the CEO of Oliver Bell Incorporated and the founder of the Texas Labor and Employee Relations Consortium. As a non-attorney practitioner of human resources, labor relations, and positive employee relations strategies, I believe I have a valuable and relevant perspective on these proposed rules. Just quickly, a background piece. Bell Inc. is a labor relations consulting firm offering advice to employers who have the goal of improving the overall work environment for their employees. Our clients are union and non-union employers who seek to provide attractive wages, benefits, and educate employees about their business. The consortium includes senior leaders in operations, human resources, and labor relations that want to stay abreast of workplace trends, implement best practices in the areas of conflict resolution, communications, leadership, wages, benefits, etc. Why is this constituency concerned about the proposed rule change? They are interested in these changes because it affects their employees. They have indicated that regardless of whatever political pressure exists, the board should resist indulging the special interests of employers, unions, or academia. Most employers understand that it is the NLRB's duty to protect the rights of employees to make a free choice regarding representation, and that it is proper that the board would encourage an election process in which employees have sufficient time to hear and process relevant information prior to voting on the issues. Should any of the board rules regarding the election process be changed? I think that there are some administrative rules which clearly would be an improvement if they were changed. In reviewing the board's election rule and regulation fact sheet, at first look, one might think that there's not much to it. Why be concerned? Change away. A closer look reveals the proposal for, in some cases, is actually genuine change for some areas and changes that reflect a fundamental shift away from protecting employee rights in other areas. The latter begs the question whether the changes, in fact, give in to special interests. Let's take a quick look at recent board performance. I won't belabor you with it because so many people have quoted that today. But our case intake was up 10% last year for FY 2010. 90% of all cases were conducted within 56 days of filing. You've heard the number 38 several times regarding the median to election, but also the average to election has been 31 days, the average time to election. And 92% of petitions have voluntary election agreements. So I think those are important things to note. And this performance evaluation would indicate that the current process is running well. So it raises the question of why change. Let me touch on that from a kind of a question and answer perspective. Do the rules protect and support employees in the election environment, or do they create a questionable and potentially unstable environment? On Form NLRB 707, NLRB Form 707, the Notice of Election, it is clearly stated that the board wants all employers to be fully informed about their rights under federal law and wants unions and employers to know what is expected of them in an election. Even the federally published Guide to the Labor Relations Act states that the purpose of creating the layman's guide was to ensure that all parties fully understand their rights and obligations under law. During representation cases, when I do consulting, we encourage employees to use all possible sources of relevant information, including radio, TV, print media, the internet, especially government agency websites and union websites, and to attend company meetings and union meetings to get information. An employee who has access to information can make an informed decision for or against unionization, and then that decision is truly in their best interests. The challenge unions have today, in my opinion, is that even though they win a majority of contested elections, often when employees have access to information, they tend to back away from unions before an election can be called. That is not an NLRB problem. That is a messaging problem. It's a challenge in communicating a value proposition of unionization, so it's not an election process problem. Does a shortened election cycle provide employees with a more democratic process or create a reckless process? I submit it would be a bit more reckless, also more harried. In the last several weeks, the term ambush election has come into vogue from several different sources. I think what this means is an election that would be viewed as a contrived process in which one party has an unfair advantage of calling essentially the time and date of the election. As a former Army officer, West Point or Airborne Ranger, one thing we learned in the Principles of War was be able to choose a time and place of battle. If you can do that, you can win the majority of the time. Also, just in terms of performance, if you look at unfair labor practices, because employers quite often bear the brunt of being told that they're bad actors. And this is historic data which has run a trend line. But in FY10, there were 23,500 and change ULPs filed. As a historic trend line goes, over 2/3 of those, or right at 2/3 of those, were dismissed or withdrawn. About 34 to 35% of those were actually settled. They might have had hearings, but they were settled. Only 1.5% actually went to hearing and had to be fully adjudicated. So that would seem to indicate that things are going well. In closing, the proposed rule changes will not result in greater rights and protections for employees. They would, in fact, result in lesser employee protections and will only favor unions, thereby creating a process that is flawed by design. May I have an additional minute, ma'am?
Surely.
Thank you. The board mission is not to advocate for or against unionization, but to advocate for a process that allows employees to make a choice free from intimidation and coercion. This should also include free from a process that might encourage process manipulation. By your own internal assessments, you are delivering well on your goals. Having a union is no guarantee of a great work life, nor is not having a union. But current private sector employees have sent a clear message. Only 1 in 14 employees is in a union currently in the private sector. They don't get the value proposition. Really, employees are business people. This is about the deal. If they think the deal is good, they're gonna buy into the deal. How does an employee evaluate the deal? Could be any number of things. It could be wages and benefits, it could be schedules, it could be work-life balance, it could be advancement opportunity, it could be workplace diversity. But a good deal is in the eye of the employee, and I trust them to be able to assess that, whether they're union or non-union. Finally, beyond that, I encourage expanding this inquiry. I think this is an exceptional process. And one thing I would like to do for everyone that has spoke today, my hat's off to you. And to the gentleman, Mr. Pedigo, is he still here? I mean, I think that was great that he came up and took any employee that comes up to state their opinion, whether they're in favor of unionization, whether they're not in favor of unionization. But when they have the gumption to come stand up here and let you know where they stand, I think that that's great, and I think that's important. 2 days of comment really is not enough. I have the privilege of serving also as the chairman of the board of the Texas Department of Criminal Justice. We do a number of public meetings. And if we were doing something of this scope and magnitude, you're talking about something here that will impact 100 million employees. We would probably take a little bit more than 2 days to hear what everybody has to say face to face. So if there's any way that you can expand this process, this is outstanding. Again, thank you for your time, Madam Chair.
Thank you for being here and sharing your thoughts with us. Do any of my colleagues have questions?
Yeah, I have a couple. Mr. Bell, thanks for coming and speaking.
Yes.
When you quoted this average that several of the other previous speakers quoted, this 38-day average, do you realize that that 38-day average includes stipulated elections?
I looked at it as the entire process, so I think that's great.
Okay. I would like to inform you, if you haven't already read it, that those elections that go to hearing, those processes that go to hearing, the average amount of time between petition and election is between 82 and 123 days.
Well, and I don't question that fact. I would think that there was someone that made a statement earlier also about outliers. If, according to your own statistics, 92% of the elections are by agreement, or so by stipulation. The fact that we have some that go longer, I think that that's a process. In some cases it's unfortunate, but sometimes there are complicated issues involved. In my own background, in terms of having worked a number of our cases, seldom have we had something get extended like that. I have the opportunity to work with a lot of different law firms, but I would say the overwhelming majority of our elections have occurred within 42 days from petition to election.
Okay. And you understand that the proposed rules that are under consideration now are primarily for procedures that don't really contemplate stipulated elections.
Yes, and in terms of streamlining the process itself, and maybe in the rush to get through a page and a half or however that goes, it wasn't clear. I think that some of those proposed changes actually would strengthen the process overall. I mean, I see no reason to be opposed to electronic submission. I mean, it is 2011. I think a lot of the question that has been brought up has just been in terms of human response time prior to being able to push that button to send the message off.
Thank you.
Any other questions?
Thank you very much for coming here today and sharing your thinking with us.
Thank you for allowing me to speak.